Um, Hi, Mate. I'm Ben. I'm the co-founder of ISO, and we help brands be more visible in ChatGPT. And today, I think we're going to hear some really interesting, thoughts about what is a ChatGPT or other AI search, conversations. There's been an interesting court case, I think, recently that we looked into. So if you want to maybe start by giving a bit of an introduction about yourself, and then I'll sort of dive in a couple of questions I have for you.
Absolutely. Thank you for having me on your show here. So I'm Maddie Neustadt, and I am both a technologist and a lawyer. I was an engineer for 10 years, went to law school at night, practiced in technology law, and did a large-scale focus of my practice around privacy, cybersecurity, and digital regulatory compliance, working at some big in-house names like Microsoft and NetApp. And now I run a small solo practice firm, almost moonlighting, because I also started a company, a software company that provides legal service management dashboards for in-house legal teams. And one of the big things that we focus on is ensuring we can protect attorney-client privilege for conversations within the companies about sensitive matters. So like you said, there was this recent case in the Federal District of New York that was brought by the DOJ, so the Department of Justice, against a man named Heppner, and he was accused of basically large-scale fraud, investor fraud, in fact. So he was accused of being in control and doing some self-dealing amongst a series of commonly owned companies where he didn't disclose his ownership of the companies to basically steal about $150 million from the shareholders and owners of a different company. The DOJ investigated him for securities fraud, along with a bunch of other things like lying to investigators and things that come ancillary to getting yourself in a lot of hot water with the DOJ. And as part of that, when the subpoena came across, the grand jury subpoena, so when he was subpoenaed to testify for a grand jury and knew that people were going to be testifying against him, he went to Anthropic's Claude and started asking Claude about defense strategy, legal strategies, how to avoid the subpoena, avoid the conviction, started asking and giving it a bunch of information about what he had done in order to set a legal strategy. And then he took that information to later and said, "Oh, look, I've had AI do this work for you." Okay, I'm putting words in his mouth there, but I've worked with enough tech clients that I can see them coming to me. They'll come to me and say, "Hey, I had AI do this for me. They drafted my contract terms. AI drafted my privacy notice. AI drafted my customer agreement. Can you just give it a once over? Just supervise it for me." And so I can see him doing that. I can see him going to his lawyers and being like, "Hey, I did all the work for you. Check it out." And then what happened is after he was indicted and the full litigation started, they warrant for a bunch of electronic devices in his house for evidence gathering. And as part of that warrant, they would have access to the devices as well as all the documents on the devices, the histories on the devices. And that would be things like your chat history with Claude. Heppner's lawyers went and they said, "No, we want that protected. We think we want to claim privilege on that. That can't be discovered." And legal privilege is this doctrine that exists in most of the world that allows clients to give full disclosure to their lawyers to get the best possible legal advice without that becoming evidence against them. Prosecutors and regulators have to find that evidence elsewhere. They don't get to go to the private conversations of the lawyer or the work product developed by the lawyer in preparation for trial in order to get that evidence. Laws of justice say that's a bit unfair, that people deserve their defense. They can't have to hide everything from their own lawyers. So the lawyers wanted to protect those Claude prompts and the outputs from Claude as privileged. And that went up as a separate question altogether to the courts. And the court held that no, they were not privileged. There was no lawyer involved. Claude is not a lawyer. Just straight up. That's in the holdings. Just single sentence. Claude is not a lawyer. Dispositive. The legal test for privilege requires a lawyer. So even if you looked at the other areas of legal privilege, the other legal tests for privilege,
And
the fact that
maybe
Claude
if
was
I
not
can
a lawyer
jump,
killed it. Hey, absolutely, yes.
if I
Sorry.
can jump on this one. So I think it's a good segue because you sort of started to suggest Claude is not, and as a bit of context for the people who watch, even though it's getting more famous now, but Claude is a bit like ChatGPT although it tends to be a little bit more for technical use case, I guess. And so I think there's an interesting question there, which is what is actually a conversation with AI? So
Hmm.
because first of all, it's called the chat usually or conversation, but effectively it's not really a chat because you're not talking to anyone. But at the same time, it really resembles a chat. So I
It
think
does.
there's an interesting, because yes, you're not talking to a lawyer, but are you talking? And it's also the question for agentic, AI of who's going to be responsible when AI does a mistake. It's like, is the AI some sort of product output of the work of the developers? So really, you're talking to developers because they build it, but they also maintain it and change it over time. So, or is it something on its own? And if it's something on its own, what is it?
Yeah, well, I mean, it's a predictive language model, right? It's a predictive semantic translator. It is a bunch of code. It, to some extent, is an automated response generated by computer code. So you're talking to something, and it's funny. The court holding never got into what is, philosophical question of, was it a conversation? Because courts in the past have considered, attorney-client privilege protects conversations, and the work product doctrine protects materials that are prepared. They're very similar but complementary, and like no one questioned that this chat with Claude was a conversation. There didn't
Mm,
have to be an individual on the other side in order for it to be a conversation. So that was never gotten into at like a base philosophical layer as like, are you actually having a conversation because it's
right,
a machine on the other side versus a human?
right. It was more that you were not having a conversation with a lawyer. You were having a
Right,
conversation with
right,
someone. It's like talking to a friend.
right. It was a third party. They just called it a third party. Like what that party was, whether it was a machine or a human or a dog.
Mm.
You can have a third party conversation with your dog, but it's very hard to get the dog to testify. Everything safe there?
Fine at the
Okay.
moment. Then I have a question and it's kind of like speculating, but if an AI was as good as a lawyer or sort of deemed, let's say the level of like an entry level lawyer or a very junior lawyer, would that be possible to consider the conversation privilege?
Right now, in the U.S. at least, and in the countries that I'm aware of, which is mainly the Commonwealth countries and countries that regulate the practice of law as a licensed profession. So you have to sit for a bar and be admitted or called to a bar in order to hold yourself out as legal counsel. That question as to whether or not an AI can be skilled enough to be a junior lawyer is kind of moot because no law society or bar will license an AI right
Right.
now, because the skill of say passing a bar exam or passing the examination required to show the technical knowledge, the academic knowledge, is only part of the licensing process for being a
Right.
lawyer. You not only have to pass that exam and an ethics exam, but again, these are written exams. AIs can certainly pass them, but you have to pass what's called a moral fitness test in the United States and a background check to show that you have exercised good judgment, and you have to be accountable for that judgment to maintain your license. You have to maintain your base of knowledge. You have to, in the United States, show ongoing compliance with the model rules of professional conduct, the rules of ethics. It's not, and you have to be accountable to the
Yeah.
bar, which is run in the U.S. by the state supreme courts for your practice. That's currently not possible with AI. All laws on AI and accountability having to do with AI specifically state that it is the user of AI that is accountable for what they do with the information that comes out. That's why you
Mm,
get rules like the EU AI Act regarding human supervision requirements, liability requirements. That Europe's at the forefront, as they have been in privacy law and regulating this, and saying, hey, you don't get to shift the blame to a computer for your bad decisions just because the AI supported those. You still have to have this human oversight. And to some extent,
mm,
it's qualified human oversight. Just like you wouldn't, if AI were doing medical
yeah.
examinations,
Yeah.
you
Medical
have a
is,
doc, you have a doctor overseeing the results of the AI, not the hospital administrator, not the lead janitor. it's a doctor that oversees it. So pure human oversight isn't enough. You need qualified human oversight. And that qualified human oversight is who is accountable to any injured party because of the use of AI. So if you're
Right.
only relying on yourself to be qualified human oversight for legal work, then you are fully accountable for any bad situation you put yourself in. Like somebody's
Mhm.
asked me recently, well, if it was a pro se litigant, so pro se means it's somebody who represents themselves in court. They've refused to take a lawyer. Would the pro se litigant use AI as a lawyer and maintain privilege? No. Again, no lawyer involved. And pro se litigants are often given a lot of leeway in court, but that leeway comes in the form of being told they really should get a lawyer because they
Mhm.
don't know what they're doing. They don't know the process. They don't know the rules. They don't know the evidentiary standards. They are at a
Yeah.
significant disadvantage without a lawyer, and they're reminded of that frequently.
Just on this aspect, I think you kind of touch upon something which is the distinction between the ability, an AI, and I think there were examples of this, like could very likely pass the bar today in many jurisdictions. If
The
it
written
was just
exams.
like the written exams, yeah. But there's another concept which is accountability, and that's really something that's sort of intrinsically human because it's
Hmm.
taking the sort of paying for the consequence, not just paying, but sort of assuming the consequences of your action. And there isn't
Right,
anything like this for AI at this stage. So
right,
in this sense, there is no path to AI replacing lawyers in any case because there isn't any way to have an AI that's accountable in
right.
in current form. So I think that's quite interesting. Um, Maybe do you think we can kind of look a little bit at a couple of examples? And I think this probably happens a lot already, where people might have shared information that they think was confidential or even privileged if they are involved in a court case, not realizing that really it isn't, So I think you mentioned to me a couple of examples of, maybe you're trying to do something, you're an entrepreneur. Let's say
Hmm.
you're an entrepreneur, because you are, right? So,
Right.
sometimes you have a
And I
question on,
use AI, full disclosure, I use AI regularly as an entrepreneur and as a lawyer.
so sometimes there's like a question on what do tell your partners or your investors and at what time, right? When do you want to, because there's a big question on momentum in a company. So sometimes you don't want to break with, dynamic. So like, what are the examples you think of sort of a mistake that can happen when someone is sharing information with AI that maybe shouldn't be shared?
Um, well, I mean, Hefner's a true example. Like he shared information about possibly, they don't, I don't have no idea what information he actually shared. The discovery is not public, but possibly shared information about potential crime he committed with AI to try to get legal
Discovery, by
advice.
the way, discovery, especially for those outside of the US, means like the process where all the evidence are collected and
Yes.
organized and okay.
Yes, and you have to, both parties have to share all of the facts that they discover with each other. So you
Right.
don't get to hide evidence that way. And this is like when warrants or subpoenas are issued to get information and data that's used in criminal trials and
Okay.
civil trials. Civil trials are also subject to discovery. So, confidential, if you're just sharing, company confidential information with AI, your biggest risk is that somehow the AI is trained on it and it is disclosed to competitors that are doing the same thing and then can be used to create a competitive product. So you don't no longer have a competitive advantage because that information was confidential. So, confidential information that provides value to your business, a type of intellectual property called trade secret. It's valuable because it's secret. And if you share that with a third party, you risk losing the confidentiality, losing the trade secrecy protection, and not being able to protect it. Trade
Mm.
secrets are very important if you have patents in a patent portfolio. So if
Right.
you have technology that you are seeking to patent, prior to the filing of the patent, that should all be protected as trade secrets. And there's a huge risk for technical founders who are seeking to file a patent. And, maybe they think, well, oh, ChatGPT can help me write the patent application. When you disclose all of that information to ChatGPT to draft that application, you are disclosing it without confidentiality and trade secret
Right.
protection. You could actually restrict your ability to obtain a patent on it.
Mm.
So that's a big thing to think about, even in a non-litigation section, the point of view.
Are there any way,
Patentability can be risky.
it might be a naive question, but are there any, like in an email where you mention it's confidential and privileged, then, that's a way to tell the other part that, it's confidential. Is there anything like
Mhm.
this that can help with the, you think, an AI conversation?
Uh, Not right now because it's more tied to the terms of service of the AI. Now you can go through your AI terms of service, and there are AI tools and deployment methods that
Yeah.
you can do to protect that information because there are patent attorneys using AI in order to help draft patents, but they have very specific deployments. Say, for
Yeah.
example, you can deploy Microsoft Copilot inside an Azure instance that's dedicated to your company where the information is not shared back with Microsoft and it's only used internal in your company.
Yeah.
That might be, I haven't done a full analysis, but that might be a way to keep any of that information from going out to a third party. Um, you know, the I think there's some newer things too. You can run on like local mini servers where you get
By
all
the
of the
way,
technology right there.
the French
Hmm.
AI company Mistral, which is sort of the French open AI, that's what they specialize on. It's like, deploying model on
Local deployments.
premise, so it's not cloud, and then yeah, you own basically the entire thing.
Yeah. And so you could, like, I would review those terms and find out what's shared and what's not. To what
Hmm.
extent is it shared? Now, every like SaaS provider that's processing information will probably have in their terms that they will respond to a lawful order, a court order, a subpoena, a regulatory order for data they have. So because that's the law, you have to respond to a subpoena or a warrant. Every country in the world has that law. um, that's law enforcement, and so the question is, what information do they have? And so that's what you have to figure out. If you have to configure it, have you configured it correctly to protect it? But if you have the ability to say deploy an LLM and a mini model on an on-prem server that you're actually running in your office, you have
Yeah.
much better protections that you're not sharing it with third party. If that content, if your queries never go back, if your prompts never go back, if the results are all local, those are good things to check for to make sure you haven't broken the confidentiality. Now, there's still no privilege because you don't have a lawyer involved, but
Right.
confidentiality, say for patent protection or business confidential information, that's better protected.
And I think there's something for SaaS entrepreneurs or tech entrepreneurs, which is that now there's more and more software that is using APIs from those
Hmm.
services.
Yeah.
And there may be a lot of conversation you're sending to OpenAI without the user really knowing, or without you making it super clear. I think that's I mean, I've known like many sort of tech entrepreneurs who basically decided to say very transparently, okay, now we basically send, all the conversations you're having with
I
us
think it'd be useful.
to a
Let's look
chatbot or
at
to an
the
internal AI bot, and some clients want to opt out of this. So that's, I think, like
Yeah. And
I
that's
think
like at my software company V4 Final, because we deal with legal workflows, we've specifically built it to use AIs that the customer wants to use. So if the customer's deployed an AI inside their environment in a constrained area where the information doesn't leave, then we can use that. And well, we lack all visibility, which means if there's a support issue, we have to get on the phone with them and they have to tell us what's going on because we won't see it. But we want to protect that privilege more than we want to do automated support because that's more important for the legal work our customers are doing. So we allow them to take over that control so that they get the level of protection that they want based on their business needs and their business
Mm,
risk profile. But we're
yeah.
fully aware of like those risks. So we call it radical transparency. We want to be transparent about everything we do so that the customer can make the decision on their own. But we also give them options. Like if you want to use Copilot or Gemini in an open environment, or just Azure, like our base level AI is an Azure OpenAI inside a customer based Azure tenancy with no training models enabled. Is it foolproof? Probably not, because it's still sitting in a third party hosted service in Azure, but it's better than just an open call to ChatGPT via API through an open interface on the internet.
And maybe as a way to conclude this, do you want to tell a little bit about your company is doing, and who are your customers?
Well, we do legal services delivery. So think ServiceNow. If you've ever used ServiceNow to open an IT ticket, this is more like ServiceNow, but for legal requests. You need help from your lawyers. We mostly focus on in-house lawyers. You need help
Hmm.
from the lawyer, so you open a legal ticket. And tools for IT ticket management aren't really made for legal services.
Yeah, that's great. Yeah.
Like their main metric is how fast can you close the ticket, and like the severity levels based on impact levels for number of people hit.
Mm,
And legal severity is different because it may only impact one person, but it's a huge issue.
yeah, that's good.
Or
Yeah.
and time to closure is less important because just getting bad advice fast doesn't necessarily help you.
Yeah.
So we look at different metrics and different ways to do that.
Mm,
And we have ways of protecting privilege too to fix problems like, legal giving advice in Slack channels that can then be shared with any third party, or they put advice in like Word sticky notes or the Google Doc comments, and then those documents get forwarded to opposing parties. So we've got privileged communications channels built in that are controlled by lawyers so that they can't accidentally go to third parties. And yet all of the background stays in the same context. So that if somebody has questions on legal deals, they can go to the deal specifically, and all of the context is right there, and you know exactly what happened.
okay.
So,
Oh, that's very cool.
you know, yeah, that's what we're working on.
And your clients are like large firms who have like a console
Yeah,
in-house.
we sell enterprise to B2B enterprises primarily. My background's in high tech and B2B enterprise. And right now we're small enough that it's all founder-led sales. We don't have a huge sales force, but if somebody wanted it, they're like, hey, that sounds great. We need a legal kind of front door to get legal advice for our company. Absolutely can do that. But we do focus on the client. We sell to the client, the enterprise that's getting legal advice. We don't sell to law firms,
Hmm. Hmm.
because every client would need their own tenancy deployed to produce.
Nice. I think this was super interesting.
Absolutely. I should have a blog out soon and a law review, not a law review, an Oregon Bar Bulletin article on the
Where
Hefner
where
case
where
and
can
what it
people
means.
find you? Is it on LinkedIn if
Oh,
they want to reach
LinkedIn.
out?
LinkedIn's the best way to find me. Yeah, it's just M Neustadt, LinkedIn in M Neustadt. If you want to provide a link in your podcast.
Yeah, I'll do that. Neustadt, right? Like
Excellent.
new town, new city.
Yes, it
Cool.
is. German ancestry.
Amazing. I think that was great. And see you all very soon.